Okay, good afternoon. It's a few seconds after. I'm Lou Tosi at the Shoemaker firm, and with me is Cheri Budzynski, our partner. And thanks for attending our WebEx today on what the Supreme Court, the new Supreme Court means for deference. And you know it's been talked about by everybody. So I hope what we will have for you is kind of a unique take, our own take, because everybody's got a take on this. You can read all kinds of things. And what we're going to do today is basically break this down into 3 sessions. I'm going to do an introduction to Chevron and talk about the case, what the actual case was about, its significance, a little bit of the details of the case, and I'll give you my thoughts on what I think it really means. And the reason I'm here is some of you may know, because I know some of you, I was actually counsel of record in the Chevron case. I was a younger lawyer then, and I had the honor of being in that case. So what I can bring to this is something that is unique. I was at the oral argument, I watched the bench, and I'll comment on what I think it means. Cheri then is going to talk about more about some of the things that the new justices have said, some of the more recent cases, some of the indications that there are cracks in the Chevron definition. The reason I say cracks is what this Supreme Court is going to do is anybody's guess. And then we're going to spend the last 15, 20, whatever remaining time taking questions from you all, or just Cheri and I going back and forth on some of the things that occurred to us during the conference. So let's go to the next slide. Okay, here's a surprise. Like Fox News says, news alert, news alert. But this is a news alert. The DC Circuit just this morning, in the appeal of the Trump era ACE rule, that was the rule that dealt with carbon emissions from power plants, reversed Trump's ACE rule and vacated it. I believe it's a 185-page opinion, and I like to say I read it, but I skimmed through it very fastly. The court vacated the ACE rule. I believe it left intact the rescission of the Clean Power Plan. This isn't a session on the Clean Power Plan. We can talk about it if you want to the end, but the reason this is a rock star decision is this will no doubt get appealed, and the Supreme Court's going to be right in the middle of all those legal issues that really affect and run around the Chevron doctrine. Because the Chevron doctrine, although it's a rule of statutory interpretation, raises a lot of questions about how policy set, congressional the delegation doctrine, the separation of powers, and Cheri will be talking more about that later. Just a summary of what happened in that case. I think I read it well enough to get the gist. The case really doesn't discuss Chevron. What the case does is holds that Administrator Pruitt's interpretation of Section 111D and the word source, and we're going to talk about the word source, the agency's interpretation, which was that EPA could only impose carbon limits on power plants to the plant, not a system-wide grid approach, was incorrect. And that the agency argued that the word source, or in Section 111D, was unambiguous, meaning that when you publish a standard of performance, the standard of performance had to apply at the source, the plant. As you all may well know, the Obama Clean Power Plan adopted a system-wide definition of source and was going to force emission reduction measures across the grid. Power companies would be relatively free within serious constraints to dispatch their units based on low carbon emissions. So I thought it would be a shame, we wouldn't be good lawyers if we just didn't tell you about this. You've probably read it on your environmental feeds. It's just all over the news. and the opinion's out there somewhere. If someone wants the opinion, we could send that on to you. Just send me an email or Cheri an email. I'm sure you can find it on your own though. So there it is. That was this slide was put into the deck 15 minutes ago, just so we could let you know it's out there and say a few things. So next slide. I ran into this slide. I can't vouch for its accuracy, but it's was published by something called the Institute for Policy Integrity. I don't know if I put the citation on there. It's a group in New York, and it purports to show, excuse me, the Trump administration's record on litigation on administrative law. And I thought this is remarkable because if you believe in Chevron, if you believe that agencies' interpretation of ambiguous statutes are entitled to deference, and if you believe in the arbitrary and capricious standard for the facts, you would assume that any administration wins most of its administrative law cases. And that's been my experience over my history. But watching the news and following the cases, I began to wonder, looks like Trump's really getting beaten around. Regardless of the issue, immigration, maybe some consumer practice law, he was getting enjoined all over the country. And this, what's this chart show me? Well, this chart shows me one of the primary concerns with Chevron is courts could kind of do what they want with it. Because after all, it's all about are words ambiguous. And if you go back and read the case decided today, you'll be surprised in 160 pages of opinion how courts could twist words because they talk about different prepositions. So anyway, I wanted to highlight this. And the thought about this is that I think Chevron is under more pressure than sometimes you hear in the news. I think judges are basically already in recent cases kind of departing from it. I think there's a general unease out there in the judiciary about allowing agencies to have so much power. So when a judge believes that a president has exceeded his power, like Trump, say on the Muslim ban, in somewhat less than beneficial ways, they will step in and change it. And that's one of the problems, I think, with the doctrine. Next slide. Next slide. Okay, some of you may know this, but I found this. Chevron is among, I think it's the 7th or the 8th, most cited Supreme Court cases in history. Look at this list. It has Brown v. Board. It has the most important segregation cases. Roe v. Wade, my God. Griswold, which is a predecessor to Roe. Miranda, New York Times Sullivan. That's the idea that newspapers are generally exempt from the slander laws. Go down through it, and Chevron's right in there. And that's because, well, it's because it is what it is. It's the premier, it's one of the linchpins, along with the SEC versus Cheri and a few others. SEC Cheri was a 1943 case that forms the basis of administrative law. And in this government, to use a word that's quickly becoming unwoke, we have a huge administrative state. The agency's just making interpretations like crazy. So Chevron has become used over and over again. Thus, there's pressure on Chevron. Next slide. Next slide. This is a simple quote, but it's an important quote. It's the duty of the judges, Article 3 judges, to say what the law is. Well, if we start with the Chevron presumption, I think taken for granted that we know what it is, but just let me restate it. If a court finds a word ambiguous, they'll defer to the agency's interpretation of the word, which really means a somewhat abdication of judicial responsibility to say what the law is. Now, since the time of Marshall, we've had a lot of changes in life. Things are much more complex. much more experts. The agencies are deemed the news experts. So maybe this principle, bedrock principle of our law is being eroded, maybe practically, but I thought I'd put that up. Next slide. I think it was Obama that really cranked up the Chevron wars. And this is a quote, this is in one of his, I didn't put the exact date, I forget what it was. I think it was his second term. This quote is the famous phone and pen and phone quote, that if Congress won't act, and he's talking about climate change here because Congress had considered a carbon tax passed in the House, rejected in the Senate. He couldn't get carbon legislation. He wanted it, if you remember, but it got blocked up. So I'll direct my cabinet to come up with executive actions for climate change. This was really the underlying announcement of how he came up with the Clean Power Plan, which was reversed by Trump and semi put back in today. And Obama pushed in the environmental arena. Some people of you may remember the once in, always in policy. And he pushed all the new source review litigation, some of the interstate pollution litigation, the definition of waters of the state. Obama was a very smart man, and he had very smart people. The environmental groups really know this stuff. We're able to just twist around agency discretion in somewhat elegant linguistic ways, but take full advantage of this. And so I believe we began to stretch the administrative state, so to speak, or the interpretations more in the last 12 years. And you see, of course, Trump tried to take advantage of the same thing. Next slide. Here's one that is kicking around. I thought I'd call it to your attention. It's infecting state courts, the dissatisfaction with Chevron showing up in state courts. And here's a quote by Justice DeWine in a very important rate setting case involving Ohio Edison, which involved deference to PUCO determinations on rate setting. The court didn't actually, the majority opinion did not accept PUCO's interpretation, but DeWine took it as an opportunity in a dissent to say we need to revisit our administrative deference doctrine. For those of you involved in, IRAC cases and appeal from EPA regulations up to Court of Appeals, and there in Columbus, this might be important to note because that Court of Appeals tends to give a lot of deference to the agency reviews, to their review of agency action. And I've been picking up, as I read these cases, a little more hints of this. Okay, next slide. Okay, let's talk about the bubble case, or the Chevron case. It's remarkable how many people that I know haven't gone back and read it. And I really hadn't read it for a long time. I read it for this conference. And I want to just remind you, it was all about the US EPA bubble policy. Without the Chevron case, the ability to calculate no net increases in new source review would be substantially limited. And what the issue there was, in the Chevron case, the issue was the EPA interpretation of the word source supported by the Act. And it was important because the agency defined the source to mean the entire plant. So if one portion of the plant was modified to have a net increase in emissions, you could take advantage of reductions elsewhere. Next slide. So it was in the context of a new source review making, and those of you who have done PSD and NSR cases know that's probably one of the most arcane provisions of the Act. It's complicated, it's counterintuitive. Bob Hodenbossi knows it perfectly, as does Mike Hopkins and a few others, but that's about it. And so often you're surprised when you think you know it, or you read a case to find out you really didn't know it. It's just because someone else thinks it's different. There's a little bit of history repeating itself. This case arose after the change of the Carter administration to Reagan, Democrat, Republican, somewhat liberal to somewhat conservative. The Carter administration published a rule that allowed the bubble policy, or the definition of a bubbled source, in only attainment areas, declined to allow sources in non-attainment areas to do a no net increase calculation. I was actually in those cases at that time. When Reagan came in, surprise, sounds like Trump here, he suspended all the rules and engaged in a reconsideration of all the rules. And after he reconsidered the rules, his Ann Gorsuch administration reversed grounds and decided to allow the bubble to apply both in attainment and non-attainment areas. Of course, the Natural Resource Defense Council went to the DC Circuit. They're a friendly circuit. I really believe that. And the DC Circuit reversed the broad use of the bubble. But their rationale, the Supreme Court case talks about it, wasn't on any statutory text. It was that the policy under the Clean Air Act to enhance air quality could occur faster if the bubble were limited in non-attainment areas. Now, what was the EPA, the statutory definition of source? Any building, structure, facility, installation which emits. I always thought that was ambiguous. You know, it's the building, or is it the unit? I always kind of struggled with that. Found my way through by asking Bob how to interpret it. But next slide. So what happened at the Supreme Court? And I was there. I have this take on Chevron and what it really means. It doesn't mean if the statute's ambiguous, rely on the agency. I think what it means, the court saying, if we are really, really, really confused and we can't understand this stuff, we'll defer to the agency. I may have given a cite down here. There's a cite to the audio tapes. You can listen to that argument. And about midway through that argument, Justice O'Connor goes off on questioning that no one can figure out. But the court, that's the context in which this court case came. It came out of reversing the DC Circuit, who essentially wholly relied on their interpretation of policy to get to a result. And Chevron in that context is not that stunning a decision. To look at the words, think about the words. The court looked at the legislative history also, found an ambiguity in one of the most ambiguous parts of the act, and deferred. Since that time, court after court has just used that like a crutch. Oh, statute's ambiguous, defer with the agency. I've been in cases before where it was just clear that the courts just didn't prefer our interpretation. You can next slide. Oh, one thing I'll comment, at that time, this is one of the, there was a lot of stuff in the trade press that the DC Circuit was acting up. They were referring to themselves as the second court of appeal, second highest court in the land. And they were issuing decision after decision based on policy. So some of us at the time believed that Chevron was an attempt of the Supreme Court to kind of put them back in their place. Couple more thoughts here. Why do I say Chevron's not actually getting, in practice, all the power? Some of you may have read the Maui case, where Breyer wrote a decision on the question of do you need an NPDES permit for discharge of groundwater. And the operative languages were discharged from a point source, right? Another ambiguity. In that case, EPA had a clear policy statement interpreting the act, and that was not followed. And what did Breyer do? I think from a law professor standpoint, what he did was amazing. He established this multi-factor test, kind of like a common law test, not an administrative law test. He told the agency to go back and do rulemaking and enforce his decision. And the agency under Trump's done that. They have announced a notice for comment. They're well along. But if you read Maui, as I read it, I thought, where's Chevron? Where's Chevron? So I've seen case after case where Chevron just isn't even mentioned. And by the way, Chevron did not bear on the decision today. The decision today turned on a pure legal interpretation. Quite a remarkable decision. A little bit about the future, then we'll turn it over to Cheri. What I think the current debate on Chevron is a feeling that agencies have gone too far. I think there's been 2 or 3 more generations of judges and lawyers since then. And those lawyers and judges have been influenced by more Scalia-type principles of limited government. Scalia's had a big impact on many, many judges, even if they don't adopt his interpretation doctrines, they are indeed doing it. If they don't say they're adopting, they are indeed. And one of those doctrines, and it's an old doctrine of little use, some people think it's obsolete, is the Anti-Delegation doctrine, which essentially holds that if Congress confers too much power on the executive branch, that violates separation of powers. Now, just a few words from me on these judges. Thomas and Alito are pretty outrightly hostile to Chevron. Why? Because just what I said, it confers too much power. Gorsuch is skeptical about it, and he's expressed, I believe, some real concerns on the separation of powers or the delegation, which, by the way, a concurring opinion in today's decision also picks up on. And we don't know much about Barrett, but she seems to be a pretty strict constructionist, and she's going to fall into that mold. What will the Supreme Court do? It's anybody's guess. I predict they will not entirely reverse it, but I predict they'll cut back on it. And here's a bold prediction. We can bet our money now. If anybody wants to send me an email and have a side bet with me. This decision will get decided as a result of today's Supreme Court case. That case is going to go up, and the whole Clean Power Plan mess has started again. So thank you for your time, and we'll turn it over to Cheri at this point.
You can go to the next slide. So what I'm going to talk about now is that there's not just one type of deference. Lou focused on Chevron, which is the highest level of deference. But if we look at, there's actually different levels that the courts use when they're looking at agency actions. The first, as we mentioned, is Chevron, and it is the highest level of deference, and it applies when an agency is looking at a statute. So it's a very specific looking at statutory reading, and I will go into detail on each of these types of deference in the next couple slides, but that's the key to know. The second one is our deference, and this is probably the one that has been criticized the most. And it actually was challenged just recently in the Supreme Court, and it was upheld, but it was also severely limited. And this is where an agency is interpreting its own regulations. And then Skidmore deference is actually a very old type of deference, but it's still around. And this is the lowest level of deference that a court will give to an agency. And this is where it is interpreting opinion letters, manuals, and guidance. In some way, it strikes me it's interesting that the highest level of deference is given when an agency is interpreting a statute, but not its own guidance. You would think that in some ways it would be the other way around, but it isn't due to Chevron. Next slide. So as Lou mentioned, I'm going to go over this very briefly on Chevron because we've already talked about it, but the whole issue here was how you could regulate pollution emitting devices. And so it had to do with the bubble, as he mentioned. When this regulation was created, the DC Circuit vacated the regulation, and that's how it ended up at the Supreme Court. And the question was, does the Clean Air Act permit the EPA to define the term stationary source to mean whole industrial plants only, which allows the plants to build or modify units within the plant without a permit required under the Act? As you can see, this definition was definitely industry friendly, and it was actually supported by the industry. Next slide. And so what Chevron deference, what came out of this case is a two-step process. And so in the first step, the court looks at the statute and they try to determine if it is unambiguous in its intent. If it is, the court must uphold the congressional intent and basically override the regulation that was created by the agency. However, if they find that there is ambiguity in the expression, then they go to step two, which is the agency's interpretation reasonable, or is it vague and ambiguous? And if they find it's a reasonable interpretation, the agency interpretation is likely to be upheld. That's the Chevron deference right there. And obviously, if it's not reasonable, then there is an impermissive interpretation of the agency regulation. Next slide. Our deference is a little bit different, and this refers to a Supreme Court case where a group of police officers had argued that they were entitled to overtime pay under the Fair Labor Standards Act. And I should point out that even though we're talking primarily environmental law here because that's our expertise, administrative law hits so many areas of law. And so it really, the issue of deference has a very wide impact on agency regulations. So in this case, the board argued that the policemen were not entitled to overtime pay because they fell under an exemption of the law pertaining to anyone employed in executive, administrative, or professional capacity. Both the district court and the U.S. Court of Appeals for the Eighth Circuit found for the board, and it was appealed to the Supreme Court. And the question here was, must sergeants and lieutenants in the St. Louis Police Department be paid for working overtime pursuant to the Fair Labor Standards Act? Next slide. So the Supreme Court affirmed the board, that would be the agency interpretation, that the policemen were in fact paid on a salary basis, and therefore they did not have to pay them overtime. They were exempt from it. And so the hour deference here basically said that an agency's interpretation of its own ambiguous regulations should be given controlling weight unless the interpretation is plainly erroneous or inconsistent with the regulation or statute. Agency interpretation need not be well established or long-standing to be entitled deference. They must, however, reflect the agency's fair and considered judgment on the matter in question. So as you can see, it's not as strong, the hour deference is not as strong as as Chevron, but there still is a lot of deference. And as I will talk about in a little bit, this has really been the type of deference that's gone under attack quite a bit by courts and judges. Next slide. And finally, there's Skidmore Deference, which I said is the lowest level. And in this case, basically back in 1944, plaintiffs they stood around a fire hall waiting for an emergency and an alarm. They had access to food, they had access to entertainment, all sorts of things, but they only were paid during the time that they were answering an alarm. So they sued the company and argued that they should be compensated for time spent at the fire hall even if they were not answering an alarm. The district court found that the time spent in the fire hall did not constitute work under the Fair Labor Act, and the U.S. Court of Appeals for the Fifth Circuit affirmed, and it was appealed to the Supreme Court. And the question was, does the time the plaintiff spent in the fire hall constitute work under FLSA? Next slide. So the court actually held that there was no reason that time spent waiting around could not be also time spent working, especially in cases in which the conditions of employment involved waiting time. And they determined that, they said a federal agency's determination is entitled to judicial respect if the determination is authorized by statute and made based on the agency's experience and informed judgment. So under Skidmore, the level of deference given to an agency interpretation of opinions, manuals, guidance is based on the degree of the agency's care, the agency's consistency, formality, and relative expertise, and the persuasiveness of the agency position. Next slide. So it's critical to understand how important deference has become. And this is a quote from a law review article that the late Justice Scalia had written. And he says, Chevron has proven a highly important decision, perhaps the most important in the field of administrative law. In the first 3.5 years after its announcement, up to the beginning of 1988, Chevron was cited by lower federal courts over 600 times. That's how important this case was to shaping what we now know as administrative law.
Hey, can I interrupt? Can I interrupt
Yep.
you? Cut. I'm not supposed to, but I can't help myself. You know, this quote by Scalia, and people say this all the time, he likes Chevron. But Cheri, you remember the Michigan versus EPA case, but that was the MAC standards for power plants. Yep. And that he wrote the majority opinion. I'm looking at it now just to be sure. Yeah.
Well, I should clarify, he's not liking Chevron in this law review article. He's just pointing out that it's been very, very important to administrative law.
Oh, I thought he liked, okay. But anyway, in that case, EPA set the MAC standards, and the court ruled that the words appropriate and necessary meant that EPA had to consider the costs, because EPA took the position they didn't have to consider the cost of the standard. And I think the words appropriate and necessary are pretty ambiguous. I mean, I personally like the result, okay? But that's one of the problems with, my view of the problems with Chevron in the community. I'm sorry for interrupting you, but.
Okay, next slide.
Go ahead.
So this is an interesting slide because if you recall the one that Lou posted at the very beginning of the Trump administration, you're going to see it's a very stark contrast to what he has encountered versus if you look generally at administrative law. And this basically gives you the 3 levels, Skidmore, Chevron, and Auer. And you can see that based on the percentage of cases in the population, it's relatively small for most, you know, when you're looking at all cases overall. But these are agency decisions that are frequently challenged. And when you look at this, it's quite striking because in most cases, the agency wins over 75% of the time, which is basically in stark contrast to what Lou showed with this agency. And we'll kind of get at the point that we're going to talk about in the last part, which is it really a deference that the agency is getting, or are the judges deciding when deference should be provided to an agency decision? And you can see that overwhelmingly, normally, the agency wins from 73 to 90% of the time. And you may want to ask, well, what's the pro of giving an agency deference? And some of the things that have been cited is, one, it's very efficient. You know, the agency is making these regulations. They are the people who know it, and it's really efficient to just let them make the regulations and the judges uphold them. It also makes sense because the agency has expertise. This is particularly true when you look at environmental law, because in environmental law, there are some complex issues. And as Lou alluded to in the oral arguments, some judges are going to have a difficult time actually interpreting these environmental statutes and laws. So the expertise always makes sense. And then what most people argue is that it does delegate the authority. The executive branch delegates this authority to its agencies, and that authority is allows them to do it, and you should be deferential to them. Next slide. However, in the past couple of years, the Supreme Court is starting to really question deference, and there is a changing tone in the court. It tends to be more conservative that it's challenging it than the liberal side of the court. And so I just wanted to highlight a couple cases in which this deference was not outlined so much in these cases. So the first one is Pereira. And this is an immigration law case. And in this case, there was a law that said that people who have stayed in the United States illegally may be allowed to legally remain if they meet certain continuous residency requirements. And the clock for this continuous residency would stop when there was a notice to appear before an immigration hearing. And in this case, the petitioner had overstayed his visitor's visa, and he received a notice to appear in 2006. But what he argued was that the notice did not stop his residency clock because the notice did not state a time or place to appear for a hearing, which is true. It did not have a time and place on it. The Board of Immigration Appeals has held that a notice to appear that does not contain a date or time of the hearing is nonetheless effective to end the period of continuous physical presence. The First Circuit found that this interpretation was reasonable and subject to Chevron deference. And so the case went to the Supreme Court. Next slide. So the question is, does the notice have to have time and place on it? And in this case, 8-1, the Supreme Court reversed the lower court's decision. And they said, yes, you do not have notice and you continue with your continuous residency if there is not a time and place. And where this is important is that the Supreme Court here declined to apply Chevron. And they argued that the statute in question wasn't ambiguous and therefore not entitled to deference. The court, as they said in step 1, the court need not to resort to Chevron deference, for the unambiguous statutory text alone is enough to resolve the case. And that is key because a lot of the new Supreme Court are textualists, and they are going to look at that statutory text when making decisions about deference. Next slide. This is the case that came up and was decided in 2019. This is the Kaiser case. This is where they were effectively asked to overrule our deference. In this case, the Department of Veterans Affairs had denied a Marine's claim of disability benefits. After many years, they reopened his case and awarded him benefits, but disputed when the effective date of those benefits should be. And so he challenged the interpretation of the term relevant in one of the regulations under which the agency denied him retroactive benefits. The Federal Circuit Court of Appeals upheld the VA interpretation under our deference, and the case was appealed to the Supreme Court. And there were a lot of eyes on this because this was the case where we would truly see whether or not the Supreme Court was going to eliminate our deference. Next slide. So the case did uphold our deference, but they placed clear limitations on which regulatory interpretations qualify for deference. And they said that our deference requires courts to accept the agency's interpretation of its own ambiguous regulations, but without that deference requirement, federal courts reviewing agency action should have more power to scrutinize the interpretation of the regulations. So they were critical of it, but they kept it in place. However, one of the important things that is cited in the dissent is Justice Gorsuch wrote a history of our deference, describing the decision as resulting doctrine an accident. He said this was a complete accident and should never have occurred. And he went on to explain that our is inconsistent with the Administrative Procedure Act and the separations of powers principle. That's the power that Lou had just mentioned, that they are not to be legislatures, the agency shouldn't be, that should be in Congress. In the concurring response today of the case that we were talking about, basically there's a chastise of Congress for not writing legislation to address climate change. So this is an issue that is coming up more and more. Next slide. So just to give you an idea of some of the things that are coming out of the Supreme Court, here, as I mentioned, one of the issues is the separation of powers. And the other thing that is a criticism of deference is it really strips the judicial authority away from them. It's the judges are supposed to be the ones interpreting the law. And when you give agency deference, they're unable to do that. So Justice Neil Gorsuch has said, this is again quotes from him, "Our has also become a doctrine of uncertain scope and application. The court has never offered meaningful guidance on how to decide whether the agency's reading is reasonable enough to demand judicial deference, and lower courts have drawn that line in wildly different places. Deepening the confusion, this court and lower courts have over time tried to soften ours rigidity by declaring that it might not apply in some ill-defined circumstances, such as when the agency interpretation conflicts with a prior interpretation or reflects a convenient litigating position or a post-hac rationalization for past agency action. All this has resulted in widespread confusion about when and how to apply our deference." Next slide. Similarly, Justice Kavanaugh has also basically questioned deference, and he cites back to Justice Scalia. And he says, Justice Scalia explained, "Our violates a fundamental principle of separation of powers, that the power to write a law and the power to interpret it cannot rest in the same hands." Justice Scalia pointedly noted that our was not a logical corollary to Chevron, but a dangerous permission slip for the arrogation of power. In the end, Justice Scalia said that our contravenes one of the great rules of separation of power. He who writes a law must not adjudge its violation. In short, I predict that our will someday be overruled and that Justice Scalia's dissent in Decker will be the land of the law. Next slide. So the big question is here, and it really is a big question. Justice Amy Coney Barrett, she's the newest justice on the Supreme Court. She has not written substantially about administrative law as a professor at Notre Dame, and she hasn't issued a real administrative law opinion. However, she is very, very similar in thought to Gorsuch and Justice Scalia. She believes interpreting the text. And when you look at some of her opinions, it's very clear that she looks deep at the meaning of a statute when she issues an opinion. And one could argue that she's going to be more likely to stop at step one of the Chevron deference and say there is no ambiguity in the statute and therefore the agency isn't entitled deference. But at this point, we don't know, but it looks like it will probably be challenged quite quickly. Next slide. So now we're just going to open it up, and if anybody has any questions, we would also be happy to have those questions be asked. But essentially, we were just going to talk about, what would be the impact if deference was discarded? And for those who think that agency deference is a good idea, what is the solution if it was discarded?
Yeah, we can just talk between ourselves if we get a comment, but I don't think you'll see the Supreme Court say very clearly no more deference. I think there'll be cutbacks on it, and not sure how it'll happen, but I think most of the callers are interested if they agree with this thought, is in the recent 10 years or so, maybe 15, there's been a tendency of administrations to use policy and rulemaking to avoid Congress. I mean, Trump's only legislative act was his tax bill, is that right? Maybe there were a few others. And Obama's big thing was the Affordable Care Act. Otherwise, what policy is being set by Congress? And I think that's resulted in a flip-flopping. You know, Trump spent a lot of time on doing administratively what Obama did, and now Biden's going to do the same thing. And that leaves a very uneasy way to set future and how rules apply. And it's that deference, I think, that's at the heart of it. So.
And I would also argue, I mean, when I read the concurrence in this case today, and he really chastised Congress for not doing the job of writing a law to address climate change. I think it's very important to look back, and our substantive environmental laws were written in the 70s and 80s and 1990. And if you really think about that, it's awfully hard to take something written back in that time and try to make it fit to address something that wasn't even on the radar at that time. And so one could argue that one of the ways that if we wanted to limit agency deference is we'd have to get the legislatures to do the actual law writing.
Yeah. So, see, my phone just rang there. Yeah, I'm also interested in seeing if we get any shifts, administrative law cases in Ohio. I think that'll take a lot longer. One of the things, I don't know if I mentioned it earlier, but I did try to read through that American Lung Association case today, and the more things change, the more they stay the same. The key issue in there was the agency's legal interpretation of the word source in 111D, legal or not. So that dealt with the word source again. So it's kind of full circle. Another irony, some of you may know, is Justice Gorsuch's mother was the famous Anne Gorsuch, who was the administrator of EPA, much maligned by the left, that adopted the bubble policy. So the key case on Chevron Deference was Justice Gorsuch's mother's deference. I think that's kind of a great life story. I got to meet her. In demeanor, she's entirely different than he is. He's very reserved, very cut, very dry. She was a very social, outgoing type person, just for what that's worth.
I think another important thing to point out about deference, and where maybe even I think more liberal leaning judges may be looking too, is one of the things that we've been seeing in recent years is, again, when you have a switch of administration, and how do you, if we look back at Trump in the first 90 days of his administration, he used a lot of executive orders to basically overturn almost all the climate change policies of President Obama. And it was, as I think Lou mentioned, it was Obama who did initially really ramp up the amount of executive orders that were being used, rather than, again, having legislatures do the law and it being implemented at the agency level. And I think what we're going to see is in this new administration, it's very likely that he's going to go in and he's basically going to overturn all the executive orders that President Trump put in place. And so you have this flipping and flopping back and forth. And the question is, how is a judge supposed to interpret deference in those cases? Because they usually have radically different policies.
And I think that's really I think that's a real good, important, key question. Like, who gets the deference? Does Obama get the deference when he says a rule, or Trump get the deference when he undoes it? If you read carefully into the Supreme Court case of Chevron, which I had to revisit, the court actually said that the deference goes to the current administration. Because remember, in that case, the agency flip-flopped. The Carter rule had a limited bubble. The Reagan rule undone it. And the court did say in passing, the guy in power, the president in power now gets the deference. Now, what's that? That gives us the kind of mess the Clean Power Plan is. We had it in 2015. We lost it. We got a new version somewhere around 2018, and now the new version's gone. Doesn't make much logical sense to me, but that's just the way it is.
And same could be true of the waters of the United States. In 2015, well, prior to 2015, we had the Supreme Court split basically, and most people were looking at Scalia's interpretation of waters of the United States. And then in 2015, President Obama created a new definition of waters of the United States. And then when President Trump entered, he changed it to very similar to the Scalia opinion. But what's really striking in that case too, is we literally at one point in time, while this definition of waters of the United States was being challenged, had states that actually had to follow the 2015 President Obama definition, and other states that were allowed to use the definition under President Trump. And so I believe there were 26 states that could use one definition and 26 states that could not use the other. How do you use the other definition?
That was due to the split in the circuits, right? Right.
It was due to actually them saying that the decision to interpret waters of the state was at the district level. And so it was all these different district courts were actually the ones responding one way or another. And so it was, some were giving deference to President Trump's definition, and some were giving deference to President Obama's. So it becomes a mess, frankly.
Yeah.
And it's my understanding that you're unable to be unmuted to ask questions. So if anybody has a question, there is a question panel, and we'd be more than happy to take any questions if that comes up.
And if not, there's no shame in finishing early. In fact, that's a credit in my view.
Yep. I don't have anything more. I think what we are going to see is that very soon with this new Supreme Court, we are going to see some kind of change to agency deference.
Okay. Good.
All right.
Another 30 seconds. Well, thanks for all attending, and I'm not seeing who you are, but thanks for attending. I hope you got something a little different for what that's worth, and be ready to read about the American Lung Association. The day before the inauguration of Biden, he got a big present. So thank you very much for attending.
Yep, thank you. And if you do have any questions, feel free to contact either one of us offline. So once again, thank you and enjoy your afternoon.